so much for joining us here at Chicago Lawyers Committee. My name is Michael Ortega. I am a program counsel on the economic justice team here, and I am thrilled to be moderating this conversation on advancing diversity, equity, and inclusion in uncertain times, insights from EEO leaders. Please take a minute, if you haven't already, introduce yourself in the chat. You are welcome to engage respectfully in the chat throughout the conversation. We're going to have time for Q&A at the end, and we'll pause our recording for that purpose. If you have any questions for the panelists, please use the Q&A button at the bottom of your screen. You might have to click more to access that. We'll be recording and sharing out the conversation afterwards. But as I mentioned, we'll pause during the Q&A, so that'll all stay here. I'm so excited to introduce our incredible panelists today. Kai Feldblum is president of EEO Leaders and a longtime civil rights advocate. She played a leading role in drafting and negotiating the Americans with Disabilities Act and served as commissioner of the Equal Employment Opportunity Commission, the EEOC, for almost a decade, where she led the efforts to include LGBTQ individuals under the protections of Title VII. Jocelyn Samuels is vice president of EEO Leaders and has long advanced workplace equality. As vice president for education and employment at the National Women's Law Center, Jocelyn spearheaded the campaign to enact the Lilly Ledbetter Fair Pay Act, which overturned a Supreme Court ruling that had narrowed the Civil Rights Act. Jocelyn has led several civil rights offices throughout the federal government, including the Department of Health and Human Services, the Department of Justice, and most recently the EEOC, where she served as commissioner and vice chair. And finally, Dariely Rodriguez is chief counsel for the Lawyers Committee for Civil Rights Under Law, where she provides strategic guidance for litigation and advocacy projects that advance racial justice. She previously served as Lawyers Committee's deputy chief counsel and economic justice program director, and as chief of staff for the Office of Federal Contractor Compliance Programs. Thank you all so much for being here. I can't imagine a better group of people to talk through these issues. And so, Kai, let's start with you. You and others started a group, EEO Leaders, which is a group of former high-ranking equal employment opportunity officials with experience across multiple administrations, and it's been described as a shadow EEOC. So can you share a little bit about why it was necessary to start the group and what are the goals of EEO Leaders?
Great, and welcome to everyone. Great to see folks. So it was clear within a few weeks of the second Trump administration that this new EEOC would be acting in ways that were truly qualitatively different from before. I mean, taking actions that were often contrary to the law, that were harmful to workers in terms of offering weaker legal protections, and also harmful to employers in sending out misleading characterizations of the law. So we established EEO Leaders very early, February 2025, because we wanted to have an organized and timely response to those actions. So we came together, former high-level political and career officials, and then using our collective decades of experience and hopefully the gravitas that we were bringing, we ended up doing and are doing the following things. So one, we disseminate accurate legal information. And so this webinar is a good example of that. Two, we respond in real time with documents that explains why some action taken by the EEOC is wrong. And often it's wrong on both legal and policy grounds. Three, we directly oppose some of those actions, okay, with comments to proposed rules or filing in amicus briefs. And finally, four, we are a source of knowledge and assistance for other advocacy organizations and policymakers who want to respond to these EEOC actions as well. Newsflash, we have been very busy over the last year and a half.
I can imagine. You can all check out EEO Leaders' website. They have all of the documents that they have been producing. They have a section on restoration documents, putting up some of the guidance that the EEOC has taken down. Just really, really incredible resource for navigating this moment. Um, I'd like to back up a bit and talk about just to provide a baseline for us today about what the EEOC is, how it operates, and how it's supposed to work versus how it's working now. Jocelyn, could you speak a little to that?
Of course, and I'm so delighted to be here today. Thanks so much to the Chicago Lawyers Committee for sponsoring this event and to all of you for joining. It's really a pleasure to be in dialogue with you. Um, the EEOC is the primary federal enforcement agency that is responsible for compliance with the employment non-discrimination laws that bar workplace discrimination based on race, color, sex, national origin, religion, age, disability, and genetic information. Title VII of the Civil Rights Act of 1964 has been in effect for more than 60 years, and the EEOC has also been established for more than 60 years. It is what used to be called an independent agency. That whole premise is being challenged. But in general, it is staffed by 5 commissioners, all of whom are Senate confirmed, and no more than 3 of whom can be members of the same political party. So it is bipartisan by design, and Congress's idea in creating the agency was that it would operate being informed by a wide spectrum of views. All the laws that it enforces are designed to remove artificial barriers, promote equal opportunity. They prohibit intentional discrimination, practices that may not look discriminatory, but nonetheless unjustifiably exclude disproportionate numbers of people of a particular protected group, harassment, and retaliation. EEOC uses numerous tools. At the front end, it engages in putting out guidance, regulations, fact sheets, doing outreach, having people give speeches to stakeholders so that workers understand their rights and employers understand their responsibilities. At the back end, it also takes charges of discrimination when people feel that they've been subject to adverse treatment in the workplace. Each year, it gets somewhere in the neighborhood of 90,000 charges of discrimination, which just signifies the magnitude of problems that people continue to encounter in the workplace, even though the anti-discrimination laws are decades old. EEOC investigates those charges, tries to settle them. In cases where it finds cause to believe that discrimination has occurred and the employer does not voluntarily agree to remedy the problem, EEOC can sue the employer, and ultimately individuals have the right to go to court themselves. Let me say what EEOC cannot do. It cannot engage in fishing expeditions to try to amass evidence of discrimination. It is charge-driven. It needs to have a charge filed either by a member of the public or by a commissioner to demonstrate that there is reason to believe that discrimination has occurred. It also cannot operate based on any commissioner's say-so alone. So while the chair of the EEOC has operational control, she cannot alone dictate commission policy. Any position taken by the commission is the product of consideration and vote by all 5 members of the commission. So announcements that are done unilaterally by the chair are her opinion, which certainly can carry weight, but they do not bind the EEOC unless they are the subject of an EEOC vote. Finally, EEOC cannot favor one group of potential charging parties over others. And so you'll probably hear later in this webinar about this administration's focus on discrimination against white men. That's prohibited by the law. And when EEOC gets complaints like that, it investigates them and enforces the law. But restricting their enforcement efforts to charges filed by white men or creating barriers to filing charges by other protected groups is not something that the EEOC is authorized to do.
Really helpful, Jocelyn. Thank you. I know that the EEOC has recently stopped accepting charges on the basis of discrimination for trans identity. And I think that's a good example that illustrates your point about how the EEOC needs to be equally investigating the charges it brings before it cannot engage in its own discrimination in that way.
Let me just clarify one thing, Michael, which is if people want to go to court to vindicate their rights, they have to go to the EEOC or their state fair employment practices agency first. EEOC cannot decline to accept those charges. It may not be investigating all of the charges equally. And as a result, people should be aware that they have the right after 180 days to ask the EEOC to give them what's called a right to sue letter so that they can then go into court themselves. But EEOC cannot decline to accept your charge. And people who feel like they've been subject to discrimination need to go through the administrative process first.
That's a helpful clarification. Thank you so much. I want to move us into what the EEOC and this administration have been doing with regard to what it describes as illegal DEI. So we
Michael, before you do that, I just want to make sure in terms of folks, just a slight modification in terms of the charges from trans folks and LGBT folks, Q folks. Starting in July, they did make clear that they will be investigating charges that they call fall squarely within Bostock. And the only charges really that they were not feeling like they were taking were harassment charges. I would say based on a recent case that one can argue that they have said they are taking all charges from transgender folks other than the bathroom folks. I know it makes sense to do a webinar specifically on that, but I just want to make sure that folks know that there are charges from trans folks that now the EEOC has said they're taking.
Awesome. So let's get to what this administration is calling illegal DEI. There's been a wave of executive orders starting on day one of this administration, targeting diversity, equity, and inclusion initiatives in and out of government. And the EEOC has been pretty busy. It sued the New York Times, alleging discrimination for failing to hire a white man in leadership. And it won a big splashy settlement against Planned Parenthood of Illinois. And so, Dariely, let's start with you. I'm wondering if you could just give us an overview of those actions and similar things and how we should be thinking about the context of these questions.
Sure. Thanks so much, Michael. Can you hear me okay?
Yep.
Good. Great. It's really great to be here virtually with you all in community. And I'm looking at the folks who are in the virtual room. And I'm seeing some of our fearless clients in the chat, some of our partners at the state AG offices and local civil rights offices. So it's just really, really great to see the turnout. And Michael, it's just great to be here with you all. Chicago Lawyers Committee has co-counseled with us on 2 lawsuits that we've brought challenging the anti-DEI executive orders that we saw issued in the very earliest days of the administration. The 2 cases that we've brought on behalf of 2 organizations include a lawsuit brought on behalf of Chicago Women in Trades, which I know is represented on this call, and a lawsuit brought on behalf of Freedom Network. Now, the anti-DEI executive orders they were very broad in scope and they were very vague, right? And the goal of those executive orders was basically to eliminate and deter folks from engaging in DEI activities, but they did not define what illegal DEI was. And that was hugely problematic for organizations receiving federal funding that are engaging in work to dismantle barriers to equal opportunity. So take the example of Chicago Women in Trades. They do really important work, and they've been doing this work for decades to dismantle barriers for women who are underrepresented in non-traditional jobs. So jobs in the trades, jobs in construction, plumbing, etc. Jobs that historically women have been locked out of, and disproportionately Black and Latina women have been shut out of those jobs. And I like to always lift up the quote that Jane Valinga, the executive director of the organization, made in the declaration, which is that the executive order was basically asking her and other folks who engage in equity work to look at the sky and make pretend it's not blue, right? It's basically asking us to think that racism is over, that discrimination is over, that everyone is on equal footing and has equal access to jobs. And that is just not the case. I think that is part of the agenda of this administration to erase our history, to erase the real lived experiences of the most marginalized community members in our country. And luckily, we have very courageous organizations that have been willing to step up and challenge these executive orders. Freedom Network is an organization that engages in work to support trafficking survivors. Now, Freedom Network, they support trafficking survivors. Chicago Women in Trades, they provide training for jobs. When you think about DEI, these are not the types of things that you're thinking about. You're just simply thinking about workplace DEI, right? But the fact is that the anti-DEI executive orders have had a massive chilling effect on the very critical work that nonprofit organizations across the country do to serve our communities. And I'm proud to say that in both of those cases, we have secured nationwide injunctions prohibiting the Department of Labor and the Department of Justice from including the provision that requires organizations to engage in unlawful DEI. And the DOJ injunction in particular, it covers over 9,000 DOJ grantees that receive funding through the Trafficking Victim and Protections Act. And my understanding is that that covers more than $500 million of funding. So it is a significant win. The injunction that we obtained in the Chicago Women in Trades case that's currently pending before the Court of Appeals, and we are awaiting a ruling. I thought that oral argument went well, so we will see what happens there. And the Freedom Network injunction is still currently in place. So that is the update on the executive orders. You mentioned some of the actions that the EEOC has taken, and I know Hai and Jocelyn will speak more to some of these cases, but I'll speak more about sort of the history that led to the passage of Executive Order 11246 and Title VII in a minute, because I think it's very important for us to be grounded in the history, especially in moments like this. But it's interesting to see the lawsuit, for example, against the New York Times, because folks may know that there is still significant underrepresentation of Black and Brown journalists in print media, in every type of media, right? For Black journalists in particular, I think the representation of Black journalists in print media hovers around 6%, which is significantly lower than the representation of the Black population generally. And so it is troubling that one of our core civil rights agencies is using its very limited resources to go after instances of discrimination that perhaps do not represent, again, the systemic discrimination and racism that is being felt by the community members that we serve. And then the other thing that I'll say, we have seen this administration go aggressively after law firms that are engaging in DEI practices. And our coalition partner, Democracy Forward, they filed a lawsuit against the EEOC for issuing letters to law firms purporting to investigate their DEI practices. And they filed that lawsuit on behalf of several law students, alleging number one, that the EEOC exceeded its authority in issuing those letters, as we just heard Jocelyn very concisely describe what the true authority of the EEOC is. They cannot go on fishing expeditions. And this is exactly what that was. And as a result of that lawsuit, we learned that many law firms did not respond to the EEOC's request. They pushed back and they said, no, EEOC, you are not authorized to get this information and we're not going to turn it over to you. So as a result, I think of the collective pressure resulting from that lawsuit, the EEOC has declared that they've closed that initiative. So I think it's just a really strong example. Like all of these are examples of ways in which advocates, individual students, community leaders can really step up and push against the excess in authority that we are seeing being undertaken by this administration, really aimed at dismantling the core civil rights protections of our communities.
Thank you so much for sharing all of that. Kai, do you have anything you want to add on this front?
Yeah, so a few things. Number one, I'm glad you mentioned that letter that Andrea Lucas sent to those 20 law firms, because we actually, EEO Leaders, this is our first document we wrote. We actually got a letter out 2 days later to then acting chair Andrea Lucas saying, you cannot do this. You do not have this authority, and law firms do not have to respond. And I know there was a lot of discussion within the law firms about what to do, and I do know that a number of them had read that letter. I guess what I want to say to folks about the lawsuits, the EEOC against New York Times, or the settlement with Planned Parenthood of Illinois, looking at the chat, looking where you are all from, you know a lot of this stuff. So part of what I'm just about to say here are things that I hope you can then say to other folks, certainly stuff that we've been saying in our documents. So we know that the EEOC is using these cases to intimidate and chill legal activity by employers, right? We know that. So what I would suggest taking from the EEOC's case against the New York Times is how legally weak the EEOC's position is, right? Because in a complaint, they actually had to put out the facts, right? The factual basis for their case against the New York Times for engaging in discrimination. I'm sure a bunch of you have read those. Those facts are pathetic in terms of making the legal case, right? That New York Times collected demographic data. It had goals to increase its diversity. It had various plans on how to achieve those goals. None of that is illegal. And I'm sure the New York Times has good lawyers to fight in this case, and I'm glad that they're doing it. The one other thing I would say, and again, you all know this, but it's worth repeating to folks, there are costs in retreating from diversity efforts. There are costs. Just even what Dariely just said in terms of New York Times, if your statistics are not good, your demographic data, and then you just stop to trying to get more diversity, you could expose yourself to future legal risk of a disparate impact case, right, that's brought against you by a plaintiff's lawyer, not the EEOC, for the next few years, but that uses, among other things, the demographics of your workplace. And, I mean, bottom line, you just undermine the effectiveness of your mission or of your business interests if you step away from diversity. We know that. You all know that. It's about communicating that. So my mantra has been review, don't retreat. An employer should absolutely analyze every effort it's taking to increase the diversity of its workplace and making sure it's using legal methods. And that's what this webinar is about. That's what our documents are about. That's what you all are doing. But to sort of say to folks, review, don't retreat.
Yeah, thank you, Kai. We're seeing a lot of organizations come to us and worried about having to react in a a posture of fear and anxiety. And the tools that you mentioned, the resources that you mentioned, the kinds of reviews and assessments that we can do here at Chicago Lawyers Committee, our partners at the Nonprofit Resilience Hub are providing broader services. We're all here to help you all review your policies, review your programs, and figure out how to stay in this fight and navigate this moment. I want to touch briefly on the administration's approach to federal contractors. Earlier this year in March, there was a new anti-DEI executive order specifically targeting federal contractors, and the rules that govern people with government contracts tend to be a little bit different than other sources of federal funding. So Dariely, can you please kind of walk through that? How have these administration's actions impacted government contractors? I think you're muted.
There we go. Sorry about that. I was unable to unmute. So OFCCP is very near and dear to my heart. After I graduated law school, I actually worked on the management side, representing federal contractors in OFCCP investigations, audits, compliance reviews, et cetera. And that was when I first learned about this very small agency alongside EEOC that I think in many ways very nicely complemented the work that EEOC was doing. As Jocelyn explained, EEOC is more so driven by individual charges. OFCCP was created as a result of Executive Order 11246, which was signed by Lyndon B. Johnson at the height of the civil rights movement. And it was a part of a broader civil rights package aimed at dismantling the Jim Crow era, an era in which there was legalized racism and discrimination in the workplace. And the importance of Executive Order 11246 is that it specifically applied to employers receiving federal funds. And I did not know this at the time, 20 years ago when I started practicing law, but there's a big chunk of our workforce that works for federal contractors. I believe it's 20% of our workforce works for federal contractors. And Executive Order 11246 required those employers to undertake affirmative efforts to closely analyze their employment policies and procedures to ensure that they were not resulting in discrimination, period. And the executive order had the name, affirmative action tied to it. And so I think people hear that and think, oh, there's race-based decision happening by federal contractors. And that was not true. Like Title VII, Executive Order 11246 did not allow employers to make decisions on the basis of race, right? And even though it was passed at the height of the civil rights movement to address the systemic racism and discrimination that was being experienced by Black workers and workers of color, OFCCP, the protections under 11246, apply to everyone, right, on the basis of your protected category. So OFCCP very regularly brought investigations and cases to look into quote unquote reverse discrimination or discrimination being experienced by white workers, by male workers. That is something that OFCCP always did, right? And so it was heartbreaking, quite frankly, to see Executive Order 11246 being rescinded. I may have shed a tear or two because it was truly heartbreaking. And it was heartbreaking for me because I spent 5 years representing employers who did the hard work of really carefully analyzing their employment practices, and where they found artificial barriers, to use the language that Jocelyn used, they would take action to correct those issues, because why wouldn't they, right? Why wouldn't an employer want to have access to the best and most talented and qualified workers, right? Why would you want to turn away workers who are qualified because of some artificial barrier? For example, like requiring a master's degree when the job truly does not require it, right? And so OFCCP is still in existence, but it is not enforcing Executive Order 11246. And the administration just very recently issued a new executive order. And it's like an iteration of the anti-DEI executive order from last year, but more specifically, calling on or requiring federal contractors to not engage in racial disparate treatment or racial discrimination. And Democracy Forward has filed a lawsuit challenging that executive order, and that case is still pending. But I think it's honestly quite ironic that you had an office that was enforcing protections on the basis of race and other protected categories for everyone. They did away with that executive order, and now they're creating a new executive order. And there are a lot of problems with it, including not clearly defining what they consider to be disparate treatment. As Hai pointed out, the complaints filed against the New York Times keys you into what this administration believes to be discriminatory. Things that are lawful in their minds are discrimination, right? Engaging in outreach to underrepresented communities, et cetera. So we as a coalition will continue pushing back. In a moment, I will drop a link to a resource that our coalition developed to really break down that executive order and what it means. But we are continuing to track it very carefully. And I agree with everything that Hai said, that this is a moment, yes, where there is increased enforcement risk, particularly for organizations receiving federal funding. That is a fact. That is the reality, right? Because of that, organizations really have to carefully review their programs to ensure that they are compliant with the law. And there are real costs to backing away from these initiatives for the communities that we serve, but just for our country, right? Like, we are all here to ensure that we have a multiracial democracy that functions well, where everyone has voice, opportunity, and power. And backing away from these initiatives in this moment, because of the targeting that we're seeing by this administration is just, it's the wrong thing to do.
But yeah, I think it's a really important point that these laws for, the 60 plus years they've been on the books really do protect everybody. And so what we're seeing now when we see the attacks on these laws or suggesting that every way of advancing racial equity is somehow violating civil rights law is just wrong. But we do have to recognize that even if the legal liability analysis hasn't changed, the enforcement calculus and risk calculus certainly has. And so those are exactly the kinds of things that we're helping folks walk through. Jocelyn, can you speak to how these changes about federal contractors, right, widespread as they are, 20% of our workforce, how that affects folks who are not federal contractors? Does the EEOC do anything with these actions?
Yeah, I mean, I think what Dariely is describing and what we've all been talking about reflect an administration-wide level of attack on what they characterize as unlawful DEI initiatives. So as an employer, whether you take federal funds or not, if you have 15 or more employees, with regard to age discrimination, it's 20 or more. But for all of the other bases, if you have 15 or more employees, you are subject to EEOC's jurisdiction. And as Dariely said, the enforcement risks are exacerbated by this administration's determination to root out the kinds of proactive steps that employers have been productively taking for decades to level the playing field, particularly for groups that have historically and continue to be underrepresented in the workplace. So the bad news, as Dariely says, is, yeah, you ought to evaluate your risk calculus, and as Hai says, review your programs. But here's the good news. The president, the White House, the Department of Labor, the EEOC do not get to say what the law is. They can tell you their opinions about what the law is, but ultimately it is courts that will decide about the legality of certain employer actions. And the courts, including the Supreme Court, have continued to make clear that there are many things that employers can do to try to identify potential red flags of discrimination and to address them before they ripen into situations that will get the employer in trouble for discriminating against any group of people. So among other things, and we'll put in the chat a link to a document that EEO leaders prepared back last summer when the Department of Justice put out a sweeping condemnation of ill-defined DEI activities. Ignore the characterization. Here are some of the things that you can clearly continue to do. Data collection and analysis. As Dariely said, employers looking at the composition of their workforce has been a practice that for decades has identified situations in which there is a significant disparity between representation in a workforce and availability in the qualified pool. If there is that kind of disparity, that is a sign that the employer may be engaging in discrimination, and employers are well advised to get out in front of that and investigate. Doing training on what the law requires, on conduct that amounts to harassment, on an employer's expectations for professional conduct in the workplace, repeatedly upheld by different courts. You shouldn't engage in vilifying any protected group or using racial slurs against any group, but training is a foundation of ensuring that your employees understand the obligations of the law in the workplace. Workplace surveys to ask your employees about their concerns so that you can, again, get out in front of things that might otherwise amount to discrimination. Mentoring programs or employee resource groups that are open to your workforce and to anyone who shares the goals of the group. Not a problem. In addition, selection criteria that aren't based on race. For example, first generation practitioners of a particular trade or a commitment to working with vulnerable communities or language capacity. There is nothing unlawful about an employer using those criteria. You can also ask applicants to submit essays that talk about their own experiences overcoming challenges or adversity in their lives. There are a host of things you can do and should do because we all understand the risks of abandoning these proactive steps are that you will be depriving yourself of the broadest pool of qualified talent, exposing yourself to legal liability, and undermining your bottom line. So we're happy to be available to provide technical assistance on this front, but this is work that continues to be critical for achieving true equality of employment opportunity, no matter what the Trump administration would have you believe.
You, Jocelyn, that's really, really helpful to understand both like what what we can't do and what we can do, the ways that are free and clear lawful means of advancing diversity, equity, and inclusion. We're going to open it up for questions in a few minutes, but Kai, I wanted to give you a chance to weigh in on this question about how people should be thinking about the steps that they can take to advance DEI in this moment.
Well, I want to underscore everything that Jocelyn just said. When I said at the beginning, we want to put out accurate legal information. As she noted, we have done that in particular in response to the DOJ memo last June. I just want to add one other thing, and I have a feeling, again, looking at the folks in the chat, many of you are deep into this. And so I assume a number of you may have seen or read the book that David Glasgow and Kenji Yoshino from NYU Law School recently released, right? How Equality Wins, a New Vision for an Inclusive America. Very practical book, not a technical legal book. And it lays out how to use basically neutral, universal approaches for leveling the field for everyone, as opposed to focusing on efforts to assist a particular group. Because, of course, that's what draws the attention of the EEOC and the DOJ. And they'll sometimes think you're focusing on a particular group, even if you're not. So they have, I think, a very good roadmap in terms of universalistic approaches. I can tell you from the research that a number of those approaches do work well. One thing that I really appreciated in their book was that they were very clear, Glasgow and Yoshino, that employers lose something when they step away from efforts that focus specifically, for example, on race or gender. I mean, as they emphasize, David and Kenji, I mean, doing so can land really badly on employees and constituents when it seems so counterintuitive to how to address systemic racism or sexism. You know, the discrimination is out there, so shouldn't the focus be specific? And that can be emotionally very difficult for employees and for constituents. And I thought one of the comments, Tanisha, that you made, that if you back away from all these efforts, you will lose staff in general and their trust and productivity if they stay. So I just think that's so important. Part of why I like the Glasgow Yoshino book so much is, number one, it is offering new approaches that, as I said, from the research, some of it is very successful. But I think it's helpful that they're clear about the harmful emotional impact in adopting a universalistic approach. And I think they then provide a good roadmap for how employers can adopt these new approaches, but also acknowledge what is lost as they move in this way. And I mean, that's the sweet spot, right, that you have to hit. And I think that people like you can help employers find that sweet spot. Hopefully in coordination with all of us, all trying to get to the same goal.
Michael, if I could just add to that, I agree that this is a moment to think about new approaches. One thing that worries me, though, we also have our own initiatives supporting nonprofits that are engaging in this work. And I think because of the chilling effect, because we're seeing funders retreat from supporting work to advance equity, racial justice, et cetera, sometimes what I see is organizations overcorrecting and sort of losing sight of what the core mission of their organization is. So, for example, if you create an organization designed to dismantle barriers being faced by Native American students going into college, that is the focus, right? And creating, sort of eliminating any reference to that mission will not help advance your goals, right? There are lawful ways to advance equity to ensure that you are making progress on your very specific issue, right? And how that translates for employers is, and again, comes from representing many companies in a wide variety of sectors, large employers, small employers. Oftentimes, employers have unique issues that are specific to their industry, that are specific to their geographic area, that are specific to their workforce. And every organization, I don't care how big you are, like you have limited resources to address those issues. And so I think it's very important in this moment that we continue talking about the specific harms that different communities face, and that it is okay to design responsive remedies for those issues. So I just wanted to lift that up because it is something that I see regularly.
That's a really good
Michael,
point, Dariely.
right. I just want to add to that the point is here, it's a yes and. It's a yes and. That's the point about review, don't retreat.
Right.
And sometimes you should not be retreating from a focused effort, right? It's
The
just
way that
making
you design those policies, the way that you design those programs matters immensely for both the legal risk and the enforcement and or like government action risk. I want to move us to Q&A. And so if we could stop recording, we have a couple of great. So you three have spent your careers building, drafting, passing, and enforcing these laws, and this is certainly a critical time and lots of uncertainty around how to, do this work in the future. We've heard a lot about what is and is not the law, what has and hasn't changed, and what employers can do. But I just want to end asking you all, what gives you hope in continuing this fight? Dariely, let's start with you.
I think three things. My children. I find myself talking to them a lot about what is happening every day. And again, like really trying to ground them in our country's history and the injustices that persist. So they give me a lot of hope, and they keep me very grounded. Number two, our clients. I mean, how courageous do you have to be to step up and bring a lawsuit against this particular administration? So every day I get inspired by their courage. And then three, by my colleagues. I work with some of the best and brightest in the country, and they are just nice, even when things are really, really difficult. And their persistence and their resilience in this moment and the dedication with which they pursue their work on behalf of our clients, it really gives me the energy that I need to continue going.
Jocelyn, what about you?
Well, Dariely opened the door, so I need to piggyback to say, yes, my children give me immense joy and hope for the future, and my grandchildren, one of whom was born 8 days ago. So if anybody wants to see pictures, stay on the line. I'm happy to share. But I mean, here's what I'd say. Look, we all know these are heartbreaking, infuriating times, and it takes a lot of resilience just to get up and keep at the fight. But we all know civil rights has never been linear, and the extent of the backlash is in some ways a sign of how much progress we've made. I derive immense inspiration from all of you on this call who are so committed to pursuing the ideals that led to our civil rights laws, that we are all so committed to, and that we've devoted our lives to advancing. So I can't imagine a better village to be in this fight with, and fight it will be, but I am committed to continuing to be out there on the front lines and to doing everything that we can collectively to restore the vision that we all share.
Thank you, Jocelyn. Hi.
Yeah, well, you know what? It is. It is about all of us. I am energized by the resistance. And even just some of the comments that have just been coming in are saying exactly that. And so I'll end actually with this, which is about community. So, EEO leaders, when we started, it was one particular issue we wanted to help folks with. And, you know, we send out a meeting, Zoom list. I was looking at it recently. I called the meeting the EEOC Cavalry, right? Because we were coming in to help on this one issue. And in that conversation, we realized how much energy we got from coming together. We were not alone in this resistance. And we are stronger when we're coming together. And if anything has energized not just us who have been doing this for our careers, but lots of other people. And that's what we hold on to going forward when we start rebuilding, which we will. And we're going to do it now, not necessarily the same way as before. There's no reason to. We will move forward and correct civil rights. The struggle has not been linear, but it has been forward, and it will continue to be so.
Amazing. That's can't think of a better way to end. Thank you all so much for tuning in. We'll be circulating the links in the chat. And if you need any assistance in doing the kinds of reviews of your policies and programs, Chicago Lawyers Committee for Civil Rights and all of our partners stand ready to help. Thank you all again for coming and have a great rest of your day.
Thank you. Bye.
Bye, everyone.